My name is David Weatherford, General Counsel for Oklahoma Municipal Management Services, and today we're going to talk about specific use permits. Specific use permits are very important for understanding how cities and towns can implement zoning and regulate land use in Oklahoma. In 2003, the Oklahoma legislature approved a new law that added 3 new sections to the state statutes at Title 11, Sections 43-113 through 43-115. The purpose of the new law, as expressed in 43-113B, is that specific use permits are for uses that more intensely dominate the area in which they are to be located, or their effects on the public are broader in scope than other types of uses which are permitted in a zoning district. The real impact is that the legislature recognized that some uses of property affect neighboring properties or the community, and in those instances, we can adopt new rules to deal with those uses. Our elected officials can determine the uses that will intensely dominate an area and should pass an ordinance that lists those uses. The uses will be those that have a more dramatic impact on an area, either because of the type of use, the size of property, or the effect on the public. The mayor and elected officials for each city and town can determine the uses on the list that are needed for their city. For example, the following. A good rule to follow in making the list is to ask which uses will cause a public reaction if the use is proposed. For example, apartment complexes above a certain size will cause a public reaction. The newly approved marijuana uses have had tremendous public response. And landfills and quarries, prisons and halfway houses all cause the public to react. The process allows you to schedule an evidentiary hearing before the Planning Commission and outlines the factors that can be considered to either recommend approval or a denial. Those factors include the impact of the proposed use on adjacent property, the impact of the use on the community welfare as a whole, or the impact of the use on public facilities, such as roads and utilities. These factors allow you to consider the impact the usage will have on land values, the impact on traffic, the impact of noise and air quality, and whether the use is consistent with the city's comprehensive plan. The process will require evidence to deny a request and cannot be based on the belief that we just want to keep those uses out of our cities. These statutes also allow you to create a process that can include the following. Require an application outlining the usage, including an ability to require the applicant to provide detailed information about their proposal. We can't evaluate the application without knowing the details of what's proposed. Provide for notice and a hearing before the Planning Commission, with flexibility for the Planning Commission about the notice to be given. Allow you to provide evidence to the Planning Commission either in favor of or against the proposed use, including experts, regarding the impact of the proposed use. Impose conditions on the use. The statute is clear that reasonable conditions may be required if those conditions consider the natural environment, health and welfare of residents and landowners adjacent to the proposed use, or if the condition protects the community welfare. Provide for an appeal to the City Council, Town Board that may be a limited review or an appeal that provides some protection to the elected officials by allowing them to review the evidence that has already been presented rather than conducting a new hearing. The unique benefits of the SUP process are greater control of land uses that dominate an area, and for the city ability to identify those and to rely on, quote, community welfare, end quote, as a factor. For intense uses, those that the public will be most concerned about, we have more control than we have with simple zoning. Standard of review that benefits the city. The review process is not, quote, de novo, end quote, or starting over, like it is with the standard Board of Adjustment process. Instead, the courts will give a great deal of weight to our decision, so long as it is reasonable and based on evidence that is presented. Greater burdens on the Planning Commission. Our Planning Commission will get to make substantive land use decisions and should be provided training that outlines their role and the process, the ability to insulate and protect elected officials with the appeal process. We should not be relitigating all land uses before the City Council, but instead should have an appeal process that requires those who are affected to pursue an appeal. All should be careful that the process is not abused. It is intended for intense uses that dominate an area, and we should make sure that we only use it in those instances. Specific use permits are a great tool for our cities. They provide us a great deal of authority to deal with dominant land uses and uses that the public would expect us to regulate. They can provide us a tremendous process that will benefit our elected officials and our staff by giving us the ability to provide good notice, to have a good hearing, and to determine whether the use is appropriate. If there are problems with the intended use, we can place conditions on it. And if there are uses that we just simply can't approve, the statute gives us an ability to deny that use. For more information about specific use permits or other services provided by Oklahoma Municipal Management Services, please visit our website.